afternoon, and you're listening to Australia's approach to patent claim construction. I'm impressed that you're here to actually listen to this subject. It is, I think, probably a relatively dry subject. I'm sure you'll agree with me in regard to that, but I think it's actually a pretty important subject. It goes to the core of what we do. For the patent attorneys in the room, it certainly goes to the core of what we do in our role. If we think about claim drafting, well, I think about all the talks I've heard at this conference, and there's a lot of talks about how to you analyse patents, you can exploit them, you can license them, you have to litigate them. A lot of it comes back, obviously, to interpreting the claims, construing the claims, and so it's a pretty basic subject in many ways. And as patent attorneys, we're tasked with the job of having to draft patent claims and patent specifications, meeting the requirements of all these different countries around the world, and keeping them all in mind. We had an earlier session on Europe where we heard lots of horror stories about the difficulties you can face there, and it's just one example of issues that we can face as drafters. So claim construction, it's one of those dry subjects, but core to what we do. So I'm pleased you've come along to hear at least what the Australian approach is to the subject, and it's good that we're going to be followed by Marcus and Gally, who will give you the Canadian approach as well. So you'll get an opportunity to compare and contrast, and I think if you listen to us, I suppose you can then cogitate and think about your own practice and how it's different. Probably won't surprise you that Australia's legal system is based on the English common law. We were a colony of the UK, and we still share our queen with the English. And we've had our Patents Act for about 110 years now. It's undergone significant revision over that time, and it's going to undergo significant revision again in 2013. I know there's been already sessions at this conference touching on some of the things that are happening in 2013, so I won't talk on those today. The position is, of course, is that the patent law, while we have this common history, the patent law in the UK and Australia has diverged, and it's diverged mainly because of the UK moving away from its original basis and its original patent law when it went into the European system. So in many respects, the Australian approach to patent law is what the UK law used to be, but it's sort of modified and morphed over the years as the Australian courts have looked at the provisions and have interpreted them in their own way. In thinking about claim construction, I just make the brief but perhaps obvious point that there's nothing in the patent legislation that gives you any guidance at all as to how to interpret a patent claim. It is purely common law. It is purely something that is ultimately developed by the courts in Australia. In looking at court actions, they're typically heard together. The patent validity and claim infringement matters are always heard together. We don't have separate proceedings. Occasionally, claim construction is something that's addressed as a preliminary question, but it is only occasionally. Most of the time, if you're in a patent litigation, all of the issues are going to be considered. Claim construction will come up, and then you'll move on to deal with other issues. There has been one or two cases more recently where the parties have agreed with the court effectively that at the end of the day, it's the claim construction is the key issue here. Once we've got the court's view on claim construction, we're going to know where we stand, and we probably won't proceed with the matter beyond that. And that's been a little bit unusual. The federal court has been conducting a trial in Australia with a view to trying to expedite patent litigation matters, looking at getting the parties to agree on issues of relevance, limit the scope of discovery, and also looking to hot tub, as it was described. I'm not sure if that's a term that's internationally sort of understandable, but hot tub your technical experts, bring them in before the judge and get them to thrash out issues and look for areas of where they agree and also areas where they disagree, rather than spend countless days in the court hearing from different experts. What the courts are trying to do is bring those experts together and really thrash out some of the issues right up front. Saying that, though, it is a role for the court alone to construe a patent specification, and certainly while experts can assist in that regard, it is ultimately always going to be the judge that's going to make the call. And just as a point there, juries play no role in Australian patent litigation. So I'll run through a few of the principles, and basically I sort of mentioned this point. It's probably not surprising that the construction of the patent is logically antecedent to all other issues. If you've got to deal with construction up front, it is basically always the first issue that's dealt with by the courts in litigation, patent litigation. And again, it's not surprising that the courts have had to try to address the issue of literal versus non-literal, the approach to interpretation of the claims. It's long been realised that it's unfair just to take a strict literal approach to claim construction, that you need to in some way broaden the boundaries in regard to your approach to interpretation of patent claims. And the position is that the Federal Court in Australia adopts the purposive approach to claim construction. And I'm sure most of you know what that purposive approach is. It probably applies in some of your countries still. And it comes out of the House of Lords decision in Katnick, Lord Diplock's decision, where he looked at an invention which I understand was a window lintel or a door lintel, and was faced with the term vertical in the claim. And the question really in the interpretation or the construction of that claim and the construction of the term vertical was, well, is vertical exactly vertical, or is something up to, say, 7 degrees, does that fall within the scope of that claim? And in that case, Lord Diplock ruled that, well, something that's within a few degrees in regard to a door frame or a window frame was fine. That did fall within the scope of the claim, and that was a reasonable and appropriate approach to the interpretation of that claim. Lots of detail in that case, and I've got a little bit up there on the screen, but I'm not proposing to go through it. I think a lot of you probably studied the Katnick decision over the years, but it is the basis of Australia's approach to claim construction. And certainly there's been plenty of cases subsequent to that have looked at that decision, both in the UK and Australia. And while the UK decisions no longer are directly applicable in Australia, they are looked at favourably. And we've had Lord Hoffman in both Improver and Kieran talk to the issue of what was meant by Diplock in the Katnick decision, and those decisions are also very relevant. So essentially the current position is that we're going to have a purposive construction, and that's great. But we've got a few examples. It doesn't give patent applicants carte blanche to run an interpretation of a claim or a construction of a claim. It is quite restrictive, and the Australian approach has become, I think, quite restrictive in more recent years. While we adopt a purposive construction, the courts are really looking hard at the claim scope, really looking hard at the words that are used in the claim, and putting the onus on patent applicants and by default patent attorneys to really draft very well and ensure that we've done a good job in regard to our approach to claim drafting. And it's certainly, you can't use, for example, purposive construction to in some way seek to remove features from the claim. You'd be able to come along later and say, well, yes, I know that feature's in the claim, but it really is inessential to the invention, and no person with a fair reading of the claim is going to think it's essential. Therefore, I would like you to consider it that it's not actually there, and therefore this product over here is in fact an infringement of that claim, because obviously it's going to lack this inessential feature. Courts just are not going to buy that in Australia. They've taken the view now, it's been very clear, that they're going to assume that every feature in the claim is an essential feature. There's going to be a purposive construction around all of those claim features, but you're going to find, I believe, from now on that you're going to be held to what is in your claim. And I've got a case up there that sort of supports that. And there's another one that comes along which I'll talk to briefly as well. So, in essence, the current view in regard to purposive construction is on the screen there. It does afford a degree of flexibility to particular words and terms in a claim, but the context of the claim is important. The context of the words used in the claim and also the context of the claim within the specification is critical, as is an understanding of what a person skilled in the art would have understood the patentee to mean by the chosen language. And I'll touch briefly on a few more of these points. Just wanted to give you a few examples just to show you sort of the claim construction in practice. Bagel and Fomex, I think it's a little interesting case. It was actually one of these cases where the parties agreed that if we can deal with the claim construction, we can probably leave at that point, because once we've got the court's view on claim construction, we're going to know where we stand. And the case was about a that the claim was about a method of laying foundations, and it used the term concrete spacer. A third party came along and used a plastic spacer, and they were sued for patent infringement. And perhaps it wouldn't surprise you, but the claim was held, well, the use of the term concrete spacer in the claim was held to be an essential feature, and B, there was no ability to use purposive construction to somehow construe that was somehow you could, that concrete would cover plastic. Probably not surprising decision, but the parties did run that, and they did run that argument. And I think the court there's, it's a good little quote that I'm always talking to our trainee patent attorneys about, and that patent claims are not drafted by inexperienced or unqualified authors. So this is the approach the courts are going to take. They're looking very hard at what's in your claims, and are going to hold you to what's there. I'll skip that decision. There's another decision here of Mud Company and Cortel. And I think this is, again, a good one, that just reinforcing the point that purposive construction doesn't give you an opportunity to simply, in a sense, look to patent the idea of an invention. If somebody comes along and takes the idea of the invention but delivers the invention in a different way, it's not going to be captured by purposive construction. One of the critical points in assessing construction, of course, is the issue of the person skilled in the art. At the end of the day, it comes down to an assessment by this person. And of course, it's a hypothetical person. They never actually exist, although while you will often bring along to oppositions or court matters your expert evidence, and sometimes even the experts themselves, the reality is it's a hypothetical construct. What you are really trying to do here is put yourself in the mind of this hypothetical skilled addressee and then construe the claim in that way. And it's quite critical. So of course, we will always, if we're acting for the patentee, you'll always be tempted to construe the patent claim to support the view that you want and to support the finding of infringement. But the reality is you can't do that. You have to construe the patent taking, in a sense, the view of what this hypothetical skilled addressee would take. And many cases have turned on this issue, and depending on your point of view, you either win or lose, often on the basis of how you should set that person's skill in the art. And so the correct identification of the person is important. And there's a point there as well, is that while it can be an individual, it can often be a team as well. So you can often bring together a group of people, and they're going to be the person to which the specification is directed and would make that assessment of claim construction. Of course, one of the tensions in construing a specification is that while you should read the claim and focus on that, it's got to be read within the context of the specification as a whole. I think if the specification is directed to a particular field of technology, then you can expect the claim, even though, for example, say the specification is directed to a medical device. If the claim is directed just to an apparatus, the reality is it's going to be construed within the medical device field. It's not going to be interpreted as covering all apparatus having the features claimed. So while it's got to be read within the context of the specification, it's the scope of the claims that is critical under Australian practice. At the end of the day, they mark out the legal limits of the monopoly. You can't pick your way through a claim wearing blinkers that exclude from sight the context in which the claim is set. These are the sort of key, some key statements really looking at how the Australians approach this issue. Claims that are litigated, I think, are always ambiguous. If they're not ambiguous, you wouldn't end up in the court arguing over them. So they tend to be quite easily settled, I'd imagine. So it's often the case that when you see actions before the courts, the claims will have some sort of ambiguity built into them, or an ambiguity that needs to be addressed. For terms that are not ambiguous, you can't. The view is that you can't vary or qualify the plain and unambiguous meaning of a feature, but where they are ambiguous, it's then reasonable to turn to the body of the specification to look for guidance as to what might be the appropriate interpretation of that feature. I think one of the key things that you often have to do, and can be hard to do, is that you've got to do this job in isolation. You can't look to to the alleged infringing product and say, okay, there's a set of features there. I'm going to come back and construe my claim to ensure that it reads onto that infringing product. The approach has to be that you construe the claim and you construe the claim in isolation, in effect, come to a view as to what it does in fact cover, then turn to the infringing article to decide, or the alleged infringing article to decide whether it actually falls within the scope of the claim. And at that point you also make that assessment of whether the claim is valid in light of the prior art. Just to conclude, I just wanted to touch on a few other points about Australian practice when it comes to claims. Within preambles, the word "for" is often used. I understand in certain jurisdictions it's fairly limiting when you use that term. It's not in Australia. It'll essentially be interpreted as suitable for. So it doesn't bring a limitation into the claim at all. So if you say something like an apparatus for doing something, that for is not a limitation, it's just suitable for. So you can't import, you're not going to address, say, a piece of prior art through the use of that term. You're going to have something else in your claim if you want to be valid. The term comprising is often an issue for foreign applicants because Australian attorneys like to put in a definition of that the word comprising is being used in a non-exhaustive sense. This comes up because we had a case quite some years ago now where the court ruled that the term comprising, as used in that particular claim, was being used in an exhaustive way. So it didn't really take the term or the definition of including. It was effectively an exhaustive interpretation of the term, which I think is contrary to what most people would expect. I think in the context of that claim in that case, which I haven't got here to talk about today, it was probably actually a reasonable decision. Saying that though, we've never seen it overturned. We've never actually had any court opine on the issue of the term comprising since that decision. So Australian attorneys like to put in a definition just to clarify that the term is being used in a non-exhaustive fashion. Claiming by result or function is fine in Australia. You don't have any issues at all. We don't have any equivalent to the sort of US provisions in regard to means plus function. We don't deal with it in a special way at all. It's going to be given a pretty broad interpretation again. Methods of treatment are patentable in Australia and acceptable claim types. I think we're one of the few countries other than the US where that is possible. So if you ever, unlike, for example, Europe, so if you ever have a dealing in the medical area and you have a method of treatment, you can patent that in Australia. We've had a number of cases, including, or even more recently, a few more cases that have looked at this issue. The courts have consistently said that if there's a moral or other objection to these claims, it should be handled by the Parliament, the legislators. They've refused to do it. Despite sort of significant revision process that we went through even this year, they've not looked at this issue of patentability of methods of treatment. So I think we can safely say that they're patentable in Australia. And I'll just wrap up on this point. I think, again, just to contrast, I think, with some jurisdictions, that we don't have file wrapper estoppel in Australia. So we don't have a situation, well, you can have the situation, and I've seen this in practice, where a party will argue one interpretation before the Patent Office and then argue a different interpretation in the court in regard to a claim feature, which I think is unreasonable, but we don't have file wrapper estoppel, so you are entitled to do it. And it comes to this, sort of in the last few lines on this slide, it comes to this point that unless the claim's ambiguous, you're not really entitled to turn to the body of the specification. You really just have to focus on the claim. So if you're not even entitled to turn to the body of the specification, why should you be entitled to turn to the file wrapper of the case when you are arguing it before the Patent Office? So, yeah, no file wrapper estoppel in Australia. A couple of cases on that over the years, and we certainly have. I think that's settled law. So that's a very quick run through. I've tried to keep that pretty short, conscious of the time and the day, and hope that you've found that an interesting insight into Australia's approach to claim construction. Thank you.